Hello, and a warm welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM, coming to you from Minneapolis. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today, now in its sixth season. It's called The Most Important eDiscovery Case Law Decisions for August of 2025. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the Counsel. Questions will be answered during and at the end of the webinar. This webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars, and slides will be available after the webinar. Holly Robinson, EDRM Senior Marketing Operations Manager, is here. Holly, can you please tell us what resources are available today?
Thanks, Mary. And yes, we are loving On24 with so many ways for you, our audience, to engage. If you check out the console at the bottom of your screen, you'll see the question mark icon. This is where you can type in your questions for today's faculty, and we highly encourage you to do so. The paperclip icon is for related content. If you click on it, you'll see today's resources carefully curated for you, including the On24 engagement tools descriptions for you to download to help you better engage with the platform. Click the link to subscribe to eDiscovery Today blog and never miss a thing. It's one of the best ways to start your day. There's a link to learn more about the Honorable Judge Peck and how you can engage with him. Order your copy of Tom O'Connor's spicy newish book, eDiscovery for the Rest of Us, recently updated in collaboration with EDRM's trusted partner NextPoint. Up next on the EDRM's webinar channel on September 11th, Beyond Fines, has Johnson v. Dunn raised the stakes for AI citation errors with the Honorable Ralph Altriglier and Professor Bill Hamilton. Be sure to save your seat. And be sure to also register for next month's important eDiscovery Case Law Decisions webinar, taking place on September 29th. Speaker bios can be clicked and popped up to learn more about today's faculty. And just like on Zoom, the smiley face emoji and many more reactions to the webinar. We highly encourage you to engage with them. We're having a lot of fun with them on this platform. And then there's the Twitterbird icon for social media. Follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Holly. And our wonderful faculty starts off with Doug Austin. He is, of course, the editor of eDiscovery Today, the daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices in case law. Doug is an established eDiscovery thought leader with over 30 years' experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has written numerous articles and white papers, receiving the J.D. Supra Reader's Choice Award as a top eDiscovery author and top cybersecurity author. And Doug presents at numerous webcasts, at events, and the best conferences. We also have Tom O'Connor, the director of the Gulf Coast Legal Technology Center. And Tom O is nationally known as a consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters, where he works with firms of all sizes, including for example, the plaintiffs in the BP litigation. He has also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And Tom hosts with Rocky Messing, the eDiscovery channel on YouTube, where he and Rocky have a lovely long-form interview of Kaylee and myself from a couple of years ago. Yeah. And the Honorable Judge Andrew Peck is a Band 1 Chambers ranked senior counsel at DLA Piper. And prior to that, he served 23 years as a United States Magistrate Judge for the Southern District of New York. Before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters with extensive trial experience. And at DLA Piper, Judge Peck advises on that same copyright and trademark matters, also serves as a resource for the firm and its clients on litigation strategy and discovery issues, information governance, cross-border discovery, all from a judge's perspective. sought out as a conference speaker concerning e-discovery issues, Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on e-discovery issues. And EDRM, Kaylee, and myself, always grateful to these three gentlemen for their service on the EDRM Global Advisory Council and this webinar. Over to you, Doug.
Thanks, Mary, and welcome everybody to our August case law webinar on the EDRM network. Seems like we just did this a few days ago, because we did, about 20 days ago. So we have 5 unique cases to discuss this month, and those cases address disputes related to preservation of RAM data, court-ordered TAR procedure, deposition of opposing counsel, timing of the duty to preserve, and sanctions for failing to preserve text messages. Of course, we do welcome questions, and we'll try to get to as many as we can, and we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. That's true even if you swap out your mobile device 7 times in 8 years and don't back up your data, because those webinars, our webinars, always exist in the cloud. EDRM and the eDiscovery community lost perhaps its brightest light last week with the sudden passing of Kaylee Wallstead. And so we thought before we got started with the cases, we'd take a few moments to recognize and remember Kaylee. I put together this slide with some pictures I thought would be great to share, including a picture that Shannon Bales shared on LinkedIn last week of the trip he took with Kaylee years ago to the White House. Kaylee's Zoom background, which Brett Burney shared in the LinkedIn post, and a picture of Kaylee in mouse ears from ILTACON at Disney World a few years ago. I'm actually cut off in that picture, but I thought we would focus on her. So Mary, what would you like to say about EDRM's plans to remember Kaylee?
Well, before I do that, the cat in Kaylee's Zoom avatar picture is Bean. She's been very quiet, and she's hopped up on the table here. I'm sitting at Kaylee's dining room table, and to do this webinar. And our plans are to honor Kaylee and to ground her bright light for our community into physical manifestation. And so we will be having a virtual memorial after Labor Day. And those of you who would like to attend that, you are more than welcome. We'll also be putting up a tribute page to capture all of what is coming in on text and email and social media so that it can live longer. And we're also putting together a survey. She has helped so many people that you just don't know what it is and how did she do it, to sort of capture some of that essence. And we are continuing. We'll have a short hiatus over Labor Day, but we will be back. And she loved this webinar. It's in its 6th season because she was all about creating wonderful, repeatable events where people could gather and get great value. And with that, Doug, Tom, Judge Peck, thank you so much for going on with this. I know it's difficult under the circumstances, and I will leave it at that. And I'm ready for your first joke, Doug, and you and you guys may want to say something as well. Yes.
Sure, Tom, Judge Peck, anything you guys want to say about Kaylee?
Yeah, sure. I just was over the weekend. I kept having this one flashback, a visual, which sometimes happens in times like this, and it was back in the days of the old Legal Tech New York. And I remember it was a very cold winter day, and Kaylee was out front of the hotel taking a smoke break with Gail. They both had these long winter coats on, and their collars were up against their necks, but they were laughing. I walked out, and they both were just laughing uproariously. They both were having, I'm sure they were talking about us, Um, and they were just, like I said, the two of them with those big smiles. Kaylee was talking about something and laughing, and then of course standing there, people were coming in and out, and Kaylee knew everybody, and all of a sudden there was a group of 10 or 12 people standing there, and everybody was laughing and just having fun, to the point, at one point, one of the doormen came over, and I thought he was going to tell us, to break up the crowd, and he actually said, "Hey, what's going on?" He thought there was some celebrity in the middle of the group. Like, there's always people at the hotel, ball players and musicians. He thought somebody was there signing autographs. And I said, no, we're just here having fun with with Kaylee and some of her best friends, which is, like pretty much everybody who's at the show. And I thought that was just such a great moment, not just the visual I have in my mind of her, but of the impact she had on people and how she was able to just get all these people to stop and chat, even in the freezing cold. It was just a great memory. So.
Well, of course, Tom, you realize she was from Minnesota, so yeah. New York code was like the summer.
Good point. Good point. She wasn't uncomfortable at all. Excellent point.
The only thing I want to add is, when I clicked into the webinar platform today, and usually Kaylee was the first one there with, already posted a message to the rest of us. Then she was the first one to go live and say something. It was just so very weird not to have her here. Passing in one's sleep is probably the best way to go for the deceased, but it sucks for everybody else not getting a chance to, say things beforehand as opposed to after the fact.
Yeah. Somehow I feel, though, she knows how we feel. So, I think the one thing I'll add, and I mentioned this in the blog post I did last week, EDRM has been conducting support calls, community support calls, since the pandemic started back in 2020. Last week was the 288th call, and I think Kaylee missed like one of those. There was actually a contest for a while because she and Craig Ball neither had missed. Even Mary had missed one, I think, at one point. Then finally Craig missed one, so she was the champion of attending before I think she ultimately did miss one. But one of the things that was great about her was she and Mary would always do their updates at the end of the call, Kaylee's update really was devoted to, clearly it was about listening to everybody, and she would then recap each person who was still on the call and either provide words of praise or congratulations if they had good news, or encouragement if they were dealing with something. And I mean, she was always there to give support on those calls. And I think that just says a lot about who Kaylee was. So we could spend the whole hour talking about Kaylee, but we are here to cover some cases. So, and Kaylee would want us to do that. So we'll move on. I'll quickly note that this is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which have a link to the actual case ruling, which you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. So with that, let's get to the cases. In this case, which was covered by Michael Berman on the EDRM blog, you'll hear his name a few times today. Plaintiff alleged that defendant was reproducing plaintiff's copyrighted software in RAM memory or other temporary storage in violation of the Copyright Act. According to plaintiff, defendant's infringing acts have occurred or will imminently occur as defendant continues to operate the Belvac equipment in which the copyright software is embedded. To obtain the evidence necessary to support its claims, plaintiff sought the entry of an ESI protocol that proposed for defendant to reserve 3 categories of ESI only to the extent that this information evidences use, reproduction, preparation of a derivative work, and/or distribution of the Belvac software by defendant. Of these 3 ESI categories, plaintiff identified RAM data, other temporary files, and system logs as likely the most critical to this case. Naturally, defendant opposed plaintiff's proposal, arguing that plaintiff had not shown good cause to deviate from the District of Delaware's default standard for discovery, which identifies a list of specific categories of ESI which need not be preserved absent a showing of good cause, including deleted, slack, fragmented, or other data only accessible by forensics, random access memory, temporary files, or other ephemeral data that are difficult to preserve without disabling the operating system, and server, system, or network logs. Addressing the issue, Delaware Magistrate Judge Sherry Fallon stated, defendant's response convinces the court that the parties have not fully engaged in a meet and confer that included any exploration of compromise options. Adonis disputes that real-time capture of RAM is even possible, noting that the only programs Adonis has been able to identify create a snapshot at the time the capture is initiated. The snapshot would not be a continuous capture of RAM over time. With respect to burden, defendant represents that the breadth of the preservation requirement would cause delays in production when defendant needs to contact an outside vendor each time the equipment is rebooted or serviced. Defendant estimates the cost of the proposed preservation would total between $40,000 and $240,000, depending on certain variables, but it provides no evidence beyond a brief declaration to substantiate these estimates. So she ruled that plaintiff's motion for the entry of its proposed ESI protocol is denied without prejudice. Plaintiff has not met its burden to show good cause for the preservation of ESI as set forth in its proposed protocol. She also ordered the parties to meet and confer on the issue, stating, if no compromise is reached during the meet and confer process, any renewal of the instant motion by plaintiff should include in the briefing analogous case authorities to the extent there are any regarding the preservation of evidence of the alleged reproduction of copyrighted software, and precise and narrowly contoured language defining the scope of the ESI which must be preserved, with each side's competing proposal clearly identified for any proportions of the proposed protocol that remain in dispute. Mary has enough on her plate at this moment, so we've given her a pass this month on reading and commenting on the cases. So, Tom, I'll start with you. Adonis disputed that real-time capture of RAM was possible, but we both know that you can capture RAM with specialized forensic software. Do you think this was just an excuse on their part to keep the evidence from being collected?
No, it wasn't. And this is a great example of why you need a forensics expert when you're delving into the capturing of something other than standard documents, especially what the plaintiffs were asking for here. The short version is there's RAM and there's RAM. And I remember when I was reading this that something triggered in the back of my mind. They mentioned a PLC, a programmable logic controller, as part of the discussion for what was going on when the software was fired up. And I remembered that PLCs went back to the late 60s, and in fact even to Wang systems, and were first introduced in the automotive industry as a way of providing an alternative to hardwired relay systems. So PLCs are something that are pretty old, although they're still used in things like manufacturing and traffic light systems, elevators. They're used all over the place. And the RAM that's used to control that or to handle that is not the same as what we're used to talking about. So to make sure that I knew what I was talking about, I went to the source of all things forensic, Craig Ball, and I asked Craig if my memory was correct and could he provide some distinction, and he said, yeah, and I'm quoting now, it's key to remember that a PLC is not a consumer PC. Much of the methodology of periodic RAM and cache capture developed in the microprocessor realm doesn't carry over to proprietary machine controllers, end quote. It's a it's an apples and oranges, or maybe an oranges and tangerines discussion. But the point is, they weren't exactly wrong. They probably weren't wrong at all when it came just to the PLC being fired up. But as the judge pointed out, it was clear that neither side had really had any definition of what they were talking about, and in fact hadn't even gotten to a meet and confer. And I think they're skating on thin ice with the judge here. He specifically said there was no definition of terms such as known Adonis services, quote, and real-time retention. Some of the things that you're asking to do in getting this type of RAM wasn't being defined, and I think it was maybe assumed that it was the same as PC-based RAM when it was not. So, he clearly ordered the meet and confer to dive into this, and hopefully both sides will bring some forensics experts to that meet and confer to delve into exactly what's going on. But the bottom line is you're not going to get cache captures and temporary files, things that you normally would get in a standard RAM capture in a PC environment in this environment.
Well, I learned a lot in that answer, Tom. That was great. Thank you.
And again, all thanks to Craig Ball, because he was the one who pointed all that out. Yeah.
Yeah, but you gathered that information.
Well, you got to go. Like Judge Peck has said many times, bring your geek to court. So I went to the king of geeks.
Right, there you go. There you go. Absolutely. So Judge Peck, did you ever have a request for RAM memory in your court? And do New York courts have a similar default standard for discovery that identifies categories of ESI which need not be preserved?
I never had a request for discovery of RAM memory, at least to the best of my memory now that I've been off the bench for 7 years. I do vaguely recall that the Columbia Pictures against Burrell case, I can't remember if that was one of Jay Francis's decisions or who was the author of that, but that involved either RAM or some other form of non-traditional discovery in a copyright case. As to the second part of the question, the Southern District in New York does not, and to the best of my knowledge, still does not have any sort of default standard for what is and isn't subject to discovery. Individual judges on their practices page may have checklists or protocols or draft protective orders that can help one, but I don't think any of them go into such nitty-gritty as discovery of RAM.
Okay, interesting. So Tom, what do you think of defendant's estimate for preservation of between $40,000 and $240,000? Does that seem like a wild guess to you?
Yes.
Okay.
Let's throw some numbers up there. Yeah.
Right.
Well, as the judge said in the opinion, the estimates for the cost of the preservation could total between $40,000 and $240,000. But, quote, it provides no evidence beyond a brief declaration to substantiate those estimates, end quote. He then goes on to say, the record suggests the defendant did not investigate the cost, feasibility, or burden of doing this prior to the parties meet and confer the filing of this motion. So, yeah, I mean, this is part of the modern boilerplate language, right? Let's just throw a number up there. Hey, it's really expensive. And we'll talk about the details later.
Right. Yeah. It doesn't. Well, you want specificity. That just throwing the number on the wall and hoping it will stick doesn't exactly.
That's a pretty broad range too.
Yeah, very broad range. So, all right. Let's move on to our next case, which was also covered by Michael Berman, where Pennsylvania Magistrate Judge Martin Carlson began his ruling by stating, "Today we write the next chapter in this litigation, a case which threatens to become an epic of dysfunctional discovery. The parties have long been embroiled in contentious discovery disputes. We have repeatedly endeavored to instill in the parties a mutual commitment to cooperatively working together to resolve discovery issues in a collaborative fashion. However, today, our entreaties seem to have largely fallen on deaf ears. It is frankly astonishing that these litigants are unable to come away from an in-person meeting with a common understanding of what they have said or agreed to do. Counsel can, should, and must do better. Sounds like they're treading into Rule 1.1 territory. One of the biggest disputes was regarding ESI search protocols relating to two discovery requests. In the first one, defendants identified a universe of approximately 94,000 potentially responsive documents, while plaintiff identified a mere 1,800 responsive documents. In the second one, defendants claimed their search terms resulted in some 10,500 hits, while plaintiff search terms produced only 279 responsive documents. So a total discrepancy of over 100,000 documents between the parties. Judge Carlson ordered counsel and their ESI vendors to develop and fully implement a collaborative data-driven sample testing strategy, after which he said, the parties' latest submissions reveal that they have to an astonishing degree failed in this task. Indeed, the extraordinary degree of their mutual dysfunction is exemplified by the fact that in their warring submissions, counsel cannot even agree upon what they are alleged to have agreed to in their meet and confer session. Frankly, this inability to perform even rudimentary tasks should be a source of chagrin for all involved. So, addressing ESI sampling procedures, Judge Carlson stated, counsel's inability to agree upon sampling procedures truly places them where angels fear to tread. Since their defaults compel us to decide this aspect of search protocol, we conclude that a technology-assisted review, or TAR process, which uses computer software that learns to distinguish between responsive and non-responsive documents based on coding decisions made by knowledgeable reviewers on a subset of the document collection to establish search parameters for the entire collection, is the most efficient and effective way in which to proceed. Therefore, the parties' ESI protocol shall draw upon a statistically valid random sample and then include a TAR procedure aimed at using the smaller sample to define search parameters which achieve a 95% accuracy rate when reviewing these records. So, Judge Peck, do you agree with Judge Carlson's suggestion to use TAR to address the search discrepancy between the parties? And would you have done so if you were a judge?
I mean, the problem with directing parties to use TAR is, do they know how to use it? You know, are they then just going to fight about the various aspects of a TAR protocol? I mean, that was one of the reasons in the third of my TAR trilogy cases, Hiles against City of New York, that I said that the city as the producing party could not be forced by either the plaintiff or the court to use TAR if the producing party doesn't want to do it. You know, TAR is great. I am a big fan of using TAR, needless to say, but I don't know that, you know, parties that can't seem to agree on what they agreed upon, that ordering them to use TAR is going to be an effective solution.
Yeah, because TAR does, you're absolutely right, TAR does create its own completely new things to disagree about. So that's for sure. So Tom, Jeremy Pickens, a noted data scientist in our industry, observed by the language that TAR 1 is being specified, and he said there's better ways of doing this. Do you agree, and do you think Judge Carlson fully understood what he was requesting the parties to do?
Well, I think he totally understood what he was asking them to do. You know, I think, as he said, this has become an epic of dysfunctional discovery. What a great quote, right? I mean, you noted they were on the verge of violating Rule 1.1. I think maybe they'd gone over that line. And his quoting the angels fear to tread quote from U.S. versus O'Keefe by Judge Fasciola, I think, was a nod to that you don't want me to be making these decisions, but since you can't be making these decisions, I'm going to, and this is the easiest way to go about that. I'm just going to, yeah, there might be more better types of TAR 2, you know, automated learning, whatever. even AI, but I'm just going to go for the most basic, forthright system to use to get you people to do something,
Mm-hmm.
and let's get it done. So I think that's what was going on here.
Yeah, does seem like it. And I will note, and it's not necessarily here in the slide because limited space, that he did, I think, more or less say, hey, if you guys can come to an agreement on your own, go with it. But so far, obviously, they haven't been able to do so. So Judge Peck, when a judge refers to a case as an epic of dysfunctional discovery and says they can't even agree to what they agreed to do, it does seem like your Rule 1.1 is being invoked. So what would you do to get the parties to cooperate and get back on track?
One question I have here is not to put the blame on the wrong person, but how did the court let the case become so out of control? Judges have techniques to deal with parties who can't agree on anything, whether that technique is the old Judge Waxy approach of telling the parties to go out and videotape, although in those days probably wasn't even videotape, but record their meet and confer so the court could decide who's telling the truth about what was agreed upon or not. And Judge Waxy liked to say he had never gotten a video back. It forced the parties to actually reach agreement. So, that's one approach. Another is to have weekly status conferences to see where the parties are in discovery. And, if you're really annoyed under Rule 1.1, schedule those for Friday at 5 p.m. at the courthouse. There are things to tell the parties that you're not very happy with them. And if all else fails, appoint a special discovery master, either at one party's expense, if one is able to decide that that is the recalcitrant party, or with the parties splitting the cost up front, and then the court possibly reallocating it to the party that loses those decisions the most. So there are lots of tools. Judge should use it. There may be local culture issues that prevent the judge from doing some of this, but when a case is out of control, the court probably has a little piece of that of I should have been more hands-on with them.
Yeah, without a doubt. And I definitely thought this case seems like one that's screaming for the appointment of a special master. So we'll see if we cover any more rulings in this case. It should be interesting. But we'll move on to the next case, which was yet another one covered by Michael Bermans, who made it much easier for me to get ready for this webinar, only 20 days after our last webinar. So thanks, Mike, for the 3 decisions. One of the disputes addressed in this ruling was that defendants filed a letter motion to compel plaintiffs to produce Dr. Ann Oliverius for a deposition. Defendants sought to depose Dr. Oliverius on, among other subjects, her non-privileged communications with plaintiffs and others prior to the formation of an attorney-client relationship, including her communications with donors and others at Mount Sinai concerning Singh and the allegations in the complaint, her purported personal inquiry into Singh, her decision not to proceed with the donation, her meetings with Singh, and her public relations campaign against Singh, Mount Sinai, and others, all of which occurred when she admittedly was not acting as plaintiff's counsel. Plaintiff had several objections, including that defendants do not and cannot meet the 4-factored standard for deposing opposing counsel as set forth in N. Ray Friedman. Defendants have not shown that Dr. Oliverius's role in this litigation is so unusual as to warrant a deposition, because the only non-privileged conversation she had was with Dr. Singh. Whatever she recalls of these preliminary conversations with then potential clients would reveal her mental impressions and legal opinions, which are protected by both work product and attorney-client privilege. And at that time of their letter, discovery was mostly concluded, and all the individuals defendants identified in their motion have already been deposed, giving them a full opportunity to explore these questions in those depositions. New York Magistrate Judge Jennifer Willis stated, as the parties correctly note, N. Ray Friedman enumerates the factors to consider to determine whether opposing counsel may be deposed. 1, the need to depose opposing counsel. 2, opposing counsel's role in connection with the sought discovery and overall matter. 3, the risk of encountering privileged discovery during opposing counsel's potential deposition. And 4, the extent of discovery already conducted. So she conducted the 4-factor test, finding defendants note that the extent of Dr. Olivares' investigation and the identities of whom she spoke to prior to becoming counsel is still unknown. Defendants will only know the full details of Dr. Olivares' investigation, which defendants contend led to this litigation, by obtaining that information directly from her. She also said there are allegations and there's deposition testimony concerning Dr. Olivares' involvement for at least a year as a fact witness. This warrants questioning. And she also said, in 2019, plaintiff's counsel made multiple clear representations to Judge Broderick that during the time of these events, Dr. Olivares was not acting as an attorney for former plaintiffs. Most significant, plaintiff's counsel represented to Judge Broderick that none of the 6 factors for determining an attorney-client relationship could be satisfied at the time of those events. With 3 of the factors in favor of opposing Dr. Olivares, Judge Willis ordered her to be deposed. So, Tom, what do you think of the plaintiffs retaining an attorney that appears to have been actively involved in the case before she began representing them? Do you think that's a good idea?
Well, no. I shouldn't say no, blanket no, but it's one that you have to proceed cautiously with, and clearly fraught with peril. And as the judge, who did a really good job of looking at those 4 factors here, said, there was a lot going on before she became counsel that seemed to bear on this, including some deposition testimony and multiple representation by the plaintiff's counsel that during the time of some of those events, she wasn't acting as an attorney. So I think really that the judge wants to kind of get to the bottom of this and see what's going on there. And as I said, did a really nice job of looking at all 4 of those factors and seeing how they applied. But yeah, you're asking for trouble, right? I mean, clearly there was a close relationship here, but it seems like you're just asking for trouble.
Does seem that way to me. So let's see what Judge Peck thinks. Judge Peck, this is a case from your former district. Were you ever asked to rule on deposing counsel during your time as a judge? And do you agree with how Judge Willis handled the analysis and ruled here?
I do agree with the ruling here and the analysis. I never, to my memory, which is getting more and more random of remembering things from the past, onto our prior case there. But I don't remember ruling on it in advance. One of my favorite decisions, however, was one that was the sort of aftermath of a family divorce. And so the now ex-wife was suing the ex-husband's lawyer as a party to the litigation and was deposing him. The plaintiff then made a letter motion to me that the lawyer was not answering questions enough, sufficiently, blah, blah, blah. And they made the mistake, the plaintiff did, of giving me the whole very short transcript in which the current boyfriend of the now ex-wife said on the record something to the effect of, why don't we step outside and resolve this like men? And the defense lawyer was someone who seemed very old at the time. I don't want to look back and see how old the record says he really was, because it's probably my age. But in any event, needless to say, who got sanctioned there was not the movement, but misconduct against the boyfriend, implicitly, therefore, going with the plaintiff being sanctioned.
That's interesting. Well, yeah. you don't, yeah, that's definitely not the way you want to resolve a dispute in a deposition. So,
or at least, and it shows that the guy wasn't a lawyer, because it should have been off the record. And then as soon as the record stopped,
Right.
now let's go out
Yeah.
and punch it out.
Yeah, right. Yeah, there we go. Yes, it's timing as always, for sure. So Tom, given Dr. Oliveris' closeness to the case, how do you think the defendants should approach the deposition to ensure it's productive and they obtain the information they need?
Very carefully. Like kissing a porcupine, right?
Ooh, I like that analogy. Yeah.
Yeah. I mean, they just have to pay attention to where and when the privilege attached. When did the individual become counsel? When are you bleeding into areas that may be privileged? It's just, man, that deposition is going to be messy. That's all. I say.
Sure. I mean, I think you would probably have to really stick to a lot of factually based type questions that would be confirming certain things and not state of mind type questions where
Yeah,
argue.
good point.
Yeah.
And have a really good timeline in front of you of
Right.
what happened, especially given the statement there that there's some prior circumstances involving the doctor as a fact witness. You'd want to have a really tight timeline of who said what when in the past.
And that's probably a deposition where it would be worth it to have a special master, supervising the deposition, because I could see lots of, no, that's privileged. I'm not allowing the doctor to answer, blah, blah, blah. Let's call the court. That's the third time you've objected on, it's going to be a mess.
Yeah, I would imagine so.
Yeah, you need a referee on site, right?
Yeah, I would pay to watch that. Just saying. All right. On to our next case. And now we move to the deja vu all over again portion of our webinars. Our last two rulings are for cases we've covered earlier this year, different rulings. Here, in this one, defendants sought a permissible adverse inference instruction pursuant to the court's inherent authority, which governs non-ESI sanctions, that plaintiff deleted 3 categories of paper documents, which you see there in the first bullet point. As for the inherent power sanctions, a major dispute between the parties was when plaintiff anticipated litigation and thus had a duty to preserve. Merck said plaintiff anticipated litigation no later than December 2022, but plaintiff said she did not contemplate suing Merck until she was fired in March 2023 and escorted out of the building by security. Defendants also sought Rule 37E and Rule 26 sanctions for different considerations. Regarding the inherent power sanctions, California Magistrate Judge Thomas Hickson stated, "The court thinks the plaintiff has the better of the argument. By December 2022, plaintiff had an HR dispute within Merck, but there's no indication she was thinking of suing the company. In December 2022, plaintiff's daughter, Grace Chen, texted plaintiff a link to a lawyer referral service in Alameda County, and plaintiff did consult with a lawyer at the time. When asked, do you know when your mother first started thinking about filing a lawsuit against Merck, Chen answered, I believe we talked about her filing a lawsuit after she was fired and felt that she was wrongly terminated. Plaintiff similarly testified that she consulted with a lawyer in December 2022 where she said, despite several attorneys offering their litigation services, I declined because I was not interested in litigation at the time. Merck tries to spin plaintiff's consultation with a lawyer in December 2022 as though she had lawyered up at that point, but that's not true. Accordingly, the court finds that plaintiff's duty to preserve arose when she was terminated. That addressed the first 2 sets of documents. As for the third set of documents, Judge Hickson stated, even if plaintiff threw out the printed emails that Chen mailed her in violation of her duty to preserve, Merck was not deprived of any documents or any relevant information. There would therefore be no basis for sanctions. As for Rule 37E sanctions on ESI, Judge Hickson stated, Merck cannot show there is ESI that has been lost and that cannot be restored or replaced through additional discovery. The gating item under Rule 37E is lost ESI that can't be restored or replaced, and Merck ultimately came up empty. As for sanctions under Rule 26, however, Judge Hickson stated, everyone agrees that discovery response was false, and plaintiff's counsel knew it was false by at least the beginning of December. Plaintiff's counsel said they relied on their client, who had forgotten about the electronic communications with her daughter. But there are two problems with that excuse. First, it doesn't work because Rule 26 doesn't let counsel hand off responsibility for document collection to the client and then just hope for the best. But he also noted that counsel say they did not hand off all responsibility to plaintiffs to search for documents, and they should have located responsive communications with plaintiff's daughter. So he ordered plaintiff's attorney to pay $5,000 within 30 days. So, Judge Peck, we've seen plenty of cases where the duty to preserve began at the point a party began consulting an attorney. Do you agree with Judge Hickson here that her duty to preserve hadn't begun yet, given that a lot of his determination is based on her testimony?
Well, it's sometimes problematic if the only person testifying is somebody with an interest. We do have the daughter's testimony as well, but also there is the common sense, and employment discrimination lawsuits are very, very prevalent in the federal courts. So I'm sure Judge Hickson has seen lots of them. And it's credible that, the plaintiff was trying to work things out through HR, and not until she was fired did she decide she had no choice but to bring a lawsuit. Merely having investigated whether to hire a lawyer before that time is not enough to put it over into the reasonably anticipating litigation field. Very fact sensitive, and here Judge Hickson, read the facts the way I think it's logical to read them here.
Yeah, I agree. So, Tom, it sounds, with regards to the Rule 26 sanctions, it sounds like plaintiff's counsel did a poor job of managing plaintiff's preservation and collection of ESI. So what advice do you have for our audience to manage that process and avoid potential Rule 26 sanctions like plaintiff's counsel received here?
Well, there's two problems here that they could have overcome. The first one, the judge just points out point blank, Rule 26 doesn't let counsel hand off responsibility for document collection to the client and then just hope for the best, end quote. Okay, it's your responsibility, and so you've got to take that responsibility and do it. But even worse here, the judge's statement that, quote, everyone agrees the discovery response was false and the plaintiff's counsel knew it was false, end quote. Okay, so you're going to hand off the responsibility of the client, and then you're going to try to not admit that you knew that what they were saying was false. I mean, that's just the kiss of death. I'm amazed they only got $5,000 sanction here. If that's the case, I thought the judge was being incredibly patient with that.
Yeah, absolutely.
It's just, if you're going to, you have to do it. You have to be responsible for doing the job. Then do it correctly and report accurately to the court, even if you find a problem.
Mm-hmm.
Yeah, I don't remember from reading the decision if it mentions, what type law firm is representing the plaintiff. The $5,000 where Merck requested $25,000 sounds like a mercy reduction, which, if the law firm representing the plaintiff is a small mom and pop shop or whatever, $5,000 could well be a significant amount.
Good point.
Either we don't know from the decision, or I just don't remember what we were told about who the lawyers are.
Right.
Yeah, I don't remember specifics on the lawyers, but certainly I guess sometimes it's just, kind of a matter of sending a message. And one of the things that we've certainly covered cases that have talked about supervised collection and what have you. And, I think some people think it's like a lawyer literally standing over, saying, okay, collect this, don't collect that. And to me, it's more of a managed kind of, asking the right questions and making sure that you've addressed kind of what potential sources of ESI are out there and have a game plan for making sure they're collected. And it doesn't have to be rocket science by any means. It's just really, asking the right questions and following up to make sure these things are getting collected. Yeah, absolutely. Yeah, that came up in University of Florida conference a couple of years ago, where somebody on a project management session we were doing said, clients collect their data all the time, and my thought was, well, sure, but are you going to just say, well, I'm going to totally trust you, and as an attorney, and I don't think you necessarily want to do that. You want to have some level of knowledge of what they're doing and making sure they're checking the boxes. So definitely didn't do that here, and it was an interesting kind of case to see. So we'll move on to our last case.
Now, unless you're skipping a question in the interest of time, we had another question here.
Oh, wait. Oh, you're right. Oh, my goodness. And a good question, too. So, yeah, my goodness. We got a little wound up there.
I'm not so sure if it was a good question, okay. Doug. We'll see.
It's what I wanted to know the answer to. So Judge Peck, we have Rule 37E to govern sanctions for spoliation of ESI, but we only have a court's inherent authority to govern non-ESI sanctions, such as spoliation of paper documents. So to ensure consistency in court rulings, do you think Rule 37E should be expanded to non-ESI evidence sources, or should we have a different rule to govern them?
The Rules Committee, or several Rules Committee that looked at Rule 37E, had some very, very smart judges on it, including our old friend, Judge Grimm. While extending the ESI rule to paper might make sense, although very little is paper nowadays, what about a tire that explodes? What about a car after an accident? And I think one of Mike Berman's cases he covered recently involved a car crash. The insurer took control of the now somewhat demolished car, and time passed, and then the car disappeared, so to speak.
Oh, yeah.
So would 37E really apply to all of the other non-ESI, non-paper types of evidence? The Rules Committee thought better to leave that to the common law. And as to paper, most decisions with paper, even if it's inherent authority, tend to follow the 37E questions and outline. So I think we're okay. We'll see how, as technology changes, whether one needs to look at 37E. But for now, we're in good shape.
All right, fair enough. All right, well, I won't skip any more questions, but I was just very excited to get to this last case, which is another case we covered earlier this year, and this ruling was suggested by Judge Peck. The case stemmed from an incident back in February 2017 at MSG, in which retired New York Knicks Charles Oakley was forcibly removed from the stands in a New York Knicks basketball game. During discovery...
Doug, just to interrupt, for non-New Yorkers and non-basketball fans, MSG is Madison Square Garden, which calls itself the world's most famous arena.
Right, absolutely, yes. Sorry, MSG. I was just trying to save a little verbiage there. So yes, great point. So during discovery on the assault and battery claims, it was revealed on July 10th, 2024, that all text messages sent to or from Oakley's phone prior to February 2022 had been destroyed. Oakley's counsel disclosed this to MSG on August 2024. Oakley admitted he took no steps to preserve any potentially discoverable materials on his phone after his phone broke and he upgraded to a new device. He did not image his phone, nor did he back up his phone to a cloud-based storage service. In Oakley's own words, it was more important to have a phone than it was to preserve the data saved on his device. Initial explanations from Oakley and his counsel regarding the loss were inconsistent, and Oakley kept changing his story on how many times he replaced his phone, stating at one point he traded in his phone 3 times in 8 years, including once in 2021, and admitted he did not instruct AT&T to preserve data or image or back up his phone, despite knowing he had a duty to preserve documents for litigation. However, AT&T records obtained via subpoena definitively showed Oakley upgraded his phone 7 times in the past 8 years, must be nice, significantly contradicting his sworn testimony. The AT&T records also revealed that Oakley sent 1,113 and received 6,658 text messages in the 3 weeks following his removal, averaging 39 sent and 202 received messages per day. This increased over 250% compared to pre-incident texting habits. U.S. Circuit Judge Richard J. Sullivan found that Oakley's duty to preserve relevant text messages arose no later than September 12, 2017, when he filed the lawsuit, and also found MSG amply demonstrated that it was prejudiced by the loss of Oakley's text messages because it is more than plausible that such text messages would have supported MSG's defenses. Judge Sullivan also found no reason to think that Oakley would have complied even if counsel had taken more steps, given his admitted knowledge of the preservation duty and subsequent destruction. Oakley's conduct suggested the negligence of his counsel, though troubling, did not cause the destruction of Oakley's messages. Oakley should bear full responsibility for his spoliation. So Judge Sullivan concluded that MSG established by a preponderance of the evidence that Oakley acted with the intent to deprive MSG of its text messages in this litigation, characterizing his actions as so stunningly derelict as to evince intentionality, while denying MSG's request for dismissal of Oakley's complaint and also denying their request to preclude Oakley presenting evidence at trial that he was pushed to the ground or acted in self-defense. Judge Sullivan granted MSG's request for an adverse inference instruction at trial. Oakley was also ordered to pay MSG's attorney's fees and costs for pursuing this spoliation motion and related discovery. So, Tom, do you think that Oakley's case can rebound from this ruling, or is there no defense for his stunningly derelict failure to preserve the text messages?
Oh, man, you're killing me. Well, I think to continue your analogy, Mr. Oakley got a technical here, but it was only his first technical, and he didn't get a game disqualification.
All right. Nice analogy.
That is to say, his core allegations were not thrown out. The case was not dismissed. The core allegations were to preclude him from presenting evidence at trial that he was pushed to the ground or acted in self-defense. I mean, there's video here of what went on. There's got to be plenty of video. It's before a game at Madison Square Garden. There's probably 20 people who are capturing this on video. So, although the texts are out and he's going to get an adverse instruction, the core allegations of was he pushed are still up in the air, and he can still present evidence of that. I would love to see those videos because anybody who follows professional basketball or the Knicks knows that Mr. Oakley is not a small human being, and pushing him over would be an interesting task to accomplish.
Yeah, it certainly would be. And I remember when the incident happened, and I think even ESPN may have had footage of it, or at least partial footage. So,
I'm sure there's tons of video. Yeah. So
sure.
He can still proceed with his case, and he was assaulted and he acted in self-defense. Anything he might have said with regards to that in the text in his own defense, of course, is out.
Yeah, for sure. So, Judge Peck, we just covered a case where plaintiff's counsel was sanctioned for failures to manage discovery and Rule 26 violations. Do you agree with Judge Sullivan's decision not to sanction Oakley's counsel here?
Well, I think that some clients are harder to control than others, and I don't know Mr. Oakley, but I suspect that he was not really being controlled by counsel, but clearly they should have done more than a paragraph in their retainer agreement. The other point I'd make is, the decision was essentially a layup for Oakley, since the judge had very kind words about MSG's expert, our friend Phil Favreau.
Oh, they were. That was.
That's true. Yes, yes, that's true. Phil was on the on that side, and his testimony was taken. Yes, I would even go so far as to say a slam dunk. So, indeed. Um, so Tom, what do you think of MSG obtaining Oakley's tech? Oh, wait, what?
Stop with the basketball, please.
Oh, okay, all right. Well, I had one more, but I'll save it. Tom, what do you think of MSG obtaining Oakley's text activity via subpoena from AT&T to demonstrate how much more he was texting after the incident? Why do you think more parties don't do that?
Well, I think that they assume that it's not there. I think there's a general consensus or general belief, even in our circles, that text messages are only kept for a short period of time. Certainly, carriers try to say that or give you that impression, and that they're gone. So people don't tend to ask for them because they think if they don't get them within the first 60 days or 90 days or whatever, that they're going to be gone. But that's not, as they said in the movie Independence Day, that's not completely accurate. Most cell phone carriers delete the content of text messages fairly quickly, but they retain metadata for a fairly long time. And so this goes back to our very first case today. Get a forensics person to tell you what to do, because there's data there that you can probably get. Some metadata, some carriers store it for months or even years, things like the sender and recipient numbers, the date and time, maybe even the location of the cell tower. And of course, that all goes to the issue here of how many were there. And I can tell you, I just made a quick note. Sprint keeps metadata on text up to 18 months. AT&T keeps it up to 7 years.
Right.
And the other carriers are somewhere in between there. So there's a really good shot you could get some data. Don't assume that it's not available.
Right. Yeah. I mean, because we've seen cases where parties act like, oh, we didn't really have any text communications, and all you really have to do is request the bill and discovery to show just who they were texting with. You may not have the content, but it's pretty. Yeah, it's all there. So at least for a while, as you point out. So absolutely. So Judge Peck, this ruling and the one we covered back in January in this case was issued by Judge Sullivan, who's a circuit judge for the Second Circuit. How common is it for circuit court judges to unilaterally issue rulings in cases, and why do you think Judge Sullivan is doing so in this case?
Well, it's not unilaterally ruling on issues in the case. Some circuit judges, particularly those like Rich Sullivan, who was a district judge before being promoted to the circuit, like to keep their hand in things. So whether out of the wheel or out of whatever, but they will take a certain number of cases and then have to deal with anything that comes up in the case, whether, high profile eDiscovery issues or very boring fights about whatever, and then, the usual summary judgment motion and potentially trial. The entire case was in this situation with Judge Sullivan. It wasn't, just, gee, this looks like it's going to be fun and lots of publicity and sports pages, so let me handle this. No, it's the whole case.
Interesting. Okay. Yeah, because I hadn't really seen any cases like this before with a U.S. Circuit Court judge handling it. And I did know that he was previously the district court judge. So interesting case now for the contacts page. And we do have a date for our next webinar, which is once again on another Manic Monday, September 29th. So with that, I'll say thanks to Mary, Tom, and Judge Peck as always, and I'll turn it back over to you, Mary.
Thanks, Doug. And we would like to thank you, Tom O, and the Honorable Judge Peck for this insightful presentation and the wonderful tribute to our beloved Kaylee. Our thanks to the EDRM community for your kind attention and good wishes in this tender time. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks, Mary.